Welcome to the Trial Bible, where we break down the secrets of courtroom victories with the best trial attorneys across the country. Each episode will sit down to explore their recent winning verdicts, the key pattern jury instruction charge that made the difference, and the tools they use to hit big. Let's go. Welcome back to the Trial Bible, the show where we sit down with the best plaintiff trial lawyers in the country and take apart their biggest wins piece by piece, not for the highlight reel, but for the stuff you can actually use in your next trial. My guest today is Charles Wisell, and today we're talking about one of the harder fights in this business, suing a county for a roadway it claims it had every right to design the way it did. This is a case where the defendant, Nassau County, never once offered to pay. Their theory from day one was simple. This was a car accident between two drivers, not a design defect, and they shouldn't be in the courtroom. Charles didn't just have to prove his client was catastrophically injured. He had to prove the county knew its intersection was dangerous and did nothing. Charles, welcome to the show.
Hey, good morning, Gennady. Thanks for having me.
So you just hit on a massive case in Nassau County. I want you to walk me through the first time you heard about this case. What did you know in the first week? And at what point did you realize that this wasn't just a car accident case? This could be a roadway design case against the county.
Thanks for having me, Gennady. I got to tell you, so early on, the case was referred to me. It was referred to me directly. I went and met with the family. We did some FOIL searches. We gathered up some information, but we were sort of like boots on the ground in this case, like right off the bat. We were retained immediately. And I knew it was a catastrophic injury, and my poor client had a really serious TBI. There was no doubt about that. But the whole question was it more than just a car accident? Was it more than just two cars, slamming into each other in an intersection, allocating fault between cars? It was, did the county have any involvement? So, there was a video of the accident. One of the cars spun out of control, left the intersection, struck the child all the way down the street, away from the intersection. By all early indications, it was just a really horrific car accident with bad injuries and limited coverage. That's how it looked right when we started.
And with respect to the FOIL searches that you start doing, tell me a little bit about what kind of FOIL searches do you and the firm start to look for?
So there is intersection traffic cameras that were set up at the intersection. So this was a westbound moving vehicle. So there was a westbound camera, there was an eastbound camera. So we were able to capture all of the events leading up to the crash, at least for the, I don't know, I would say like 4 or 5 minutes that the county would actually give up the videos. That was a whole big fight. Like the county didn't want to turn over the videos, but we were able to get the videos, and we saw things in the accident that made us wonder, is there more to it? And then we heard from the parents that there's a lot of intersection accidents there, which everybody was aware of. So that sort of piqued our curiosity to like dig a little bit deeper with the county. And we did a search on all prior accidents for 30 years at that intersection.
And what did you find for those 30 years? How many accidents were there at that intersection?
At least in the last 2.5 years before this child was struck, there were 108 accidents, including the very type of accident that happened here that led to this child being injured. It was what we call an overtaking accident. So we not only knew that there was a ton of accidents happening here, but the very type that caused this child to be struck was one of the type that they knew had been happening before.
108 accidents in a span of 2.5 years seems like a lot.
It's funny you say that, because when the county engineer gets on the witness stand, what he says is, I said, boy, something to the effect like, boy, that's a lot of accidents right near two schools on the corners. And he said, you should see how many other accidents happen at other intersections. This isn't even the worst of it. And the jury was sort of horrified by that answer, because here you have a jury assembled of all Nassau County residents, and you have like the chief engineer from the county sitting up there essentially saying, yeah, it's bad, but there's worse.
So before you even get to the trial, qualified immunity is coming. And the county's going to argue that there is a discretionary planning decision that they can't be sued over. How early are you building your record to defeat that defense?
So that was the county's big defense here, but it simply didn't exist. There was no qualified immunity because remember now, when you have qualified immunity, a defense on a roadway design, they have to have conducted a study, like a full blown study. And just because you disagree with their remediation of the situation, you still lose. Like qualified immunity is essentially a blanket defense for a municipality, set up in a situation like this. They didn't do a study despite 30 years of letters, 30 years of accidents. They never did a study. In fact, what they actually did was they did traffic counts of the intersection in July of 2018. So remember, the child gets hit October 2018 and it involves pedestrian traffic at an intersection by two schools. They decide to do traffic and pedestrian counts in July. At like the end of July, I think it was like July 30th, they go out there and they're doing traffic counts of pedestrians, but school's not in session. There are no kids there. The things that you would typically see at or about the time the child was struck, tons of kids moving back and forth across the intersection. There was nobody there. It was like everyone's away at summer camp. Traffic patterns are much lighter in the summer. It was a joke. So their qualified immunity, they didn't even get the charge by the judge. When we were charged up on liability and they had charge conference and they asked for it, the judge said, well, like, show me the study. And there was nothing. So qualified immunity fell by the wayside for the county here.
Got it. So let's set this up a little bit. The plaintiff is a very young 15-year-old girl walking from school. And as she's about to get to the intersection, even before the intersection, two cars collide and one of them loses control and ends up hopping onto the sidewalk and hitting her. Correct?
On the surface, that's what it looks like. That's without the design defect. Because really what happened was you have vehicles moving westbound on Dutch Broadway, and there's three lanes, but in one of the lanes, it has in the right lane, it comes to a grinding halt because of the amount of pedestrians crossing during school hours, right? Imagine 3 o'clock, two schools let out on opposite corners. Now the crosswalk is just full of kids. So all the cars in the right lane couldn't make their right turn because they had to stop to wait for the pedestrian traffic to clear up. So you have cars pulling out of that line and out of the right lane, and they're pulling into the center lane, and they're just like, it's creating this hazard. And that's happening all the time. And that's why they call these overtaking accidents. They kept having these very type of accident was happening because people didn't know as they approached the intersection, they were going to get stuck in the right lane. And you could literally miss like 3 cycles of a traffic light. So people got impatient and they were pulling out. And there was an easy fix, but the county didn't do anything.
We'll get to the easy fix. I want to take you into jury selection. You're in a relatively tough venue. Most plaintiffs would agree Nassau County is not so plaintiff friendly. And you got to get 6 strangers comfortable with the idea that's not so intuitive, that a car accident can have more than one cause. So walk me through an analogy that maybe you used to introduce that theory. And what are you watching for when you introduce the theory in terms of these jurors' reactions?
So I use the theory and I relate it back and I tell this story about the Titanic. And everybody knows the Titanic. And even before I get into it, you warm up the jury, I don't read through how many people in your household, what's your highest level of education. I go into jury selection. I'm trying to make personal connections with the people there while at the same time figuring out, is there anything about them that's just so awful that I need to have them help themselves, talk themselves out of the case. But when I get past that little, hiccup, I use this example of multiple causes of an accident. And I bring up the Titanic because everyone has seen the movie, even though it's a little dated now. And I'll say something like, has everybody heard of the Titanic? And there was this catastrophic loss of life. And, in a beautiful, clear night, this boat just hits an iceberg and it sinks. And everybody's initial reaction is, oh my God, it's, pilot error like the boat captain was going too fast, or the lookout didn't have his binoculars, which was one of the little factoids that night. And everybody thinks a combination of, unsafe seas, the iceberg, poor lookout, speed of the boat, that caused this catastrophic loss of life and it caused the boat to sink. And I say, everyone's aware of that, right? Well, how about if I told you that when they actually looked at how the boat was fabricated, they discovered that the rivets that were used on the hull of the vessel were poorly fabricated, were subpar, and that while the boat, all of those other things were true, if the boat had been fabricated properly with the proper rivets, it may have just grazed along the iceberg and it would have gone on its merry way. And there would be no Leo DiCaprio movie. There would be no sinking of the boat, no catastrophic loss of life. So the very first bad thing that happened was that they made the boat and it was poorly fabricated, right? It may not have been poorly designed, but it was poorly made. And so that's the first bad thing that happened. And then I sort of like, is everyone open to the concept that look, you're going to see that there's two cars that have an accident at an intersection. Are you open to the concept that there's a lot more to it than that? And then I've given them the Titanic example. And I think people just sort of like, they understand where you're going. And some people just say like, no, it's a car accident. That's the beginning and the end of it. But other people, you start to put it in their mind, like, there's more for you to look at here. It's not just a car accident. And those people who show a willingness to remain open to that concept, they're on.
Yeah, that's a great analogy. I've never heard that one before. I love it. It opens the idea that there can be multiple causes here. So, knowing that the whole county's defense or part of their defense was going to be this is a money grab for these plaintiffs, did that shape in any way who you wanted in the box? Were you screening for jurors who'd be skeptical of that framing or jurors who needed to be inoculated against it?
I got to tell you, when the county stood up in jury selection, and they weren't even like, subtle about it. They just literally said, you all see what's going on here, right? Like, this is a car accident. You're going to see it's a car accident. But what the county didn't know and what they could never have understood was we had focus group that video like a bunch of times. So I already knew what people think. And not when I put my foot on the gas and said, like, well, what about this and what about that? I had run this video to focus groups over and over, and I saw certain patterns in demographics and reactions to what people thought. So I already knew that with just a little nudge, people were open to the concept that there was a lot going on here. It wasn't just an accident. Because when you showed the video and you focus grouped it, you get straight up response, car accident, car accident. And when you add little factoids, right, like one at a time, almost like scientifically, just to see the effect of one factoid. And so you say 108 accidents at the intersection, and it moved the needle. And then things started to shift. And then when you also factored in, they did pedestrian traffic studies, but they did them in July. It nudged the needle a little bit more. So see, we knew what people thought about it. Whether or not we were going to be able to bring the whole thing together like an orchestra and play our symphony was one thing. But we knew that people were open to that concept. And we knew demographics, like who was more into it than others. And so when the county went in, they just missed the boat. Like they literally went in there and said, like, this is a money grab. And they knew what they wanted to say, but it wasn't really something that I thought was going to resonate with the jury. Oh, it's a money grab. Well, okay, that's great. Back it up. And so when they actually did that, I brought up during trial that they had had these speed cameras installed during the same period of time. And so despite the fact that they didn't want to make the intersection safer, they were installing speed cameras as a money grab for the county, which brought in millions of dollars. And studies on those cameras showed no discernible effect on safety or the amount of accidents, but it was generating revenue. So, he opened the door to that. So I brought that in a subtle way. And people were just like, holy smokes. Like, here's this guy telling us they're after us for money, county money, and the county's bringing in money, but they're not doing anything to earn it. And in fact, that program was shut down because it was just so unpopular. And it was like a backdoor tax, is how they refer to it on county residents.
I want to play the video for the viewers. If you're listening to this on Spotify or Apple Podcasts, go check it out on YouTube. You'll be able to see the video there. We're going to play it for you here. I want everyone, before I start, to just pay attention to the groups of children on the right side that are going to be crossing soon, the crossing guard, and the right lane, including this gray vehicle in the right lane. And make sure to watch the black vehicle behind this gray vehicle as we play the video. So we see a car, the gray car wants to go right. The crossing guard is preventing him from doing so because of the students. And there we see the first collision, which causes the black vehicle to just speed out of control and onto the sidewalk, causing a lot of kids to go running. The first time I saw this video, Charles, I thought exactly the same thing that you had said originally. This is a tough case against the county without knowing any additional facts. The fact that this black car is changing lanes when it's not safe to do so. And then even after the collision, I mean, it's another maybe 2 or 3 seconds where they're just speeding onto the sidewalk.
So that was a tough explanation. So we actually engaged a human factors expert because if you watch the video, you ran it twice, you see that both vehicles that came into contact with one another, they both left the intersection at high rates of speed. And how does that happen? So our human factors expert was able to come in and say, look, once there is an accident and once you're faced with the stress of an accident, your reaction is not always like the safest reaction. Sometimes you just do things and, your body's reacting, there's adrenaline and you're not showing. It's like fight or flight and your flight sort of kicks in. But they experienced, both drivers, what they call pedal confusion. And it's a pretty common phenomena amongst drivers. Like, you have an accident and you think you're pressing down on the brake, but it's like split second response time and the vehicle keeps moving. So you think the brake's not working. So you're pressing even harder. But what are you really pressing on? You're pressing on the gas. So if you watch the black vehicle as it leaves the intersection, it doesn't leave at a steady rate of speed. It's almost like, when you pump the brakes, it's almost like she's pumping the gas, trying to get a reaction for the vehicle to stop. But it's like stops and starts, and the vehicle is moving forward. You can tell she's pumping the gas. And the other vehicle, the vehicle that somewhat maintained its lane that was struck by the black vehicle, she sped out of the intersection too, like she was shot out of a cannon. So she had pedal confusion too. So I think the fact that both vehicles, experienced the same thing. And the driver of that other vehicle, the one that had the head-on collision in the intersection, she had passed during the pendency of the case. So we only read from her transcript. We weren't able to actually ask her questions, but they both looked like there was pedal confusion on both. And then the jury understood it too, because, the county wanted it to appear that she was fleeing the scene of the accident. And, nothing could be further from the truth.
I want to take you into your opening statement. How much of the 108 accidents do you put in front of the jury on day one versus saving it for later?
I primed them right at the beginning. I mean, usually I open up with a statistic if there's like an available stat that's just really powerful about like the intersection or accidents or the volume and things like that. But I wanted people to understand that this was something that was happening in their own community. Like it wasn't some foreign concept where, we're looking at an intersection up in, uptown in, Manhattan. This was right dead center in Nassau County. And I felt it was something that would resonate with people that, 108 accidents in a single intersection. And on each corner of that intersection, on the one corner is a high school and a junior high. On the other corner is a grammar school, St. Boniface, with kindergarten through 8. On the other corner is a strip mall. And on the other corner is a park. I mean, talk about where you have the highest concentration of pedestrians, young kids crossing the street, and then you have a park there. So you have this older portion of the community that's going to the park every day. It's this beautiful sort of, tranquil little park, right, parked across the street from the high school. So you have every type of person from the community going there. And I thought it would just, the jury would hear, because we had like a cross section of people from Nassau County. It wasn't just like young kids who were at risk. It was everybody at the intersection, and then everyone passing through it in the cars too. So you're not just worried about the pedestrians. You're worried about like all of these people making these maneuvers that you saw in the video, because you get stuck, the lanes aren't properly designated. Crossing guard steps out, she puts her hand up, she stops traffic. You miss 3 traffic light cycles. I mean, they created this situation. It was like mayhem.
In your mindset in the jury selection process, are you leaning towards taking parents that have kids that are going through that understand what pickup and drop off is like at this time of day? Are you looking for drivers or people that don't really drive that understand these types of traffic situations?
We found through our focus groups that parents were better jurors in general for this type of case because it involves school age children. But then again, when we gauge the emotional reaction to the video and stuff like that, when we're testing the video in a focus group, everybody's emotional response to the video and the event, it was all about the same. I mean, people were just horrified by what happened here. Right. So there was actually a Ring doorbell camera, and it was facing directly at like ground zero for the collision. So that black car that you saw speed away and run down the road, there was about 5 high school age children walking on the sidewalk, and that vehicle left the roadway and it went up onto the sidewalk, and it hit 4 children, 2 of whom were very seriously injured.
Now, Nassau County is bifurcated. You do liability first and then damages, but I did see that there was a motion made to unify the trial. What ended up happening there?
So I felt that the jury needed to understand the injuries because the child wasn't going to be able to come in and testify on her own behalf at the liability trial. And I thought there needed to be an explanation as to why. So I asked for some limited medical testimony just so the jury would understand that the child is not testifying as a liability witness because she simply doesn't remember what happened. And the judge denied that motion. And I said, well, then why don't we just have a unified trial? I have a couple of experts, a couple of doctors that'll come in. We'll do it all at once. And then the judge felt that for the jury to hear damages before liability was determined was too prejudicial. There were just too much going on, and it would sort of like put their finger on the scale of how they would decide the case. But what he did allow me to do was he allowed me to discuss in jury selection what the injuries were so that I could then, in my opening and during the trial, I could explain in the liability portion why the child is going to testify a certain way. And, we in fact brought the child in on liability just to explain, what happened that day. I don't know. Did you go to school that day? I don't remember. It was powerful that they knew that this was that serious and that severe that they took the entire case more seriously.
So, with respect to the liability trial, I know you already mentioned that the town brought in the town engineer who came in and said that 108 accidents is not so bad compared to some other intersections that we're dealing with. Did you bring on any experts for liability?
So I did. I called 2 experts for liability. I called a physical engineer who had a background in traffic safety also. And he discussed the design of the roadway, all the complaints that had happened, because there were complaints going back to the 80s. And it wasn't just complaints coming in from random citizens. Like the Nassau County Police Department is writing complaint letters in the 80s to the Department of Public Works. And specifically where you saw that crossing guard stop the children, that crosswalk between the east and westbound corners on the north side of the intersection, that there had been so many accidents and so many calls for them to do something about it because people just wouldn't wait. The other thing that would happen is after the light would change, then people would make right on red and they were hitting, there were car accident at car versus car, just because everybody who had gotten backed up there because of the pedestrian traffic, they're now trying to, go about their day, and they were making right on reds. There was a ton of those type of accidents. So there were complaints and complaints, and there was even a county legislator who jumped in at some point about 3 years before this accident. The county legislator jumps in and says, like, we need to fix this. We need to do a full blown traffic study. And it just all fell on deaf ears.
Any highlights, lowlights for your case that you thought really shined on the liability, whether it was with a witness or during closings or anything like that?
I think the county engineer, just his level of indifference towards what was going on. And it was just a very matter of fact approach. Like, yeah, this is bad, I guess, but there's much worse. And we can talk about that. And he's getting objections from his own, like, the county attorney's jumping up and like trying to stem the bleeding when he came to stuff like that. But he admitted all these things. He said, like, yeah, we didn't do a study. And I said, well, gosh, you guys did traffic counts in July of 2018. Let me ask you a question then. Would you do traffic studies at Jones Beach in February, or would you rather do traffic studies at Jones Beach in mid-July, when you get a representative amount of traffic pattern, that shows the summer throng of traffic? And so he said, yeah, it was just like a really bad idea. But we just did it anyway. We were just trying to figure out what was going on, but it was completely useless. And,
Did
that
your
was one of the moments.
Sorry, did your expert give any solution to the problem as to how this could be avoided, or what the town could do, simple things that could kind of avoid this kind of situation moving forward?
And so what I found out during the trial, and I did not know this, was the county has their own sign shop, and the county fabricates and installs all of their own traffic signs. So all of the signage, like right on red, yield, all of the signage you can imagine being on county roadways, it's all fabricated and installed by the county. So it's no cost to them, essentially. And what our expert said was, if you had taken that right lane and you made the right lane a right turn only lane, right? And it was designated, and you painted on the roadway and you put signs. So now you have two indications for people approaching the intersection, way back, stay out of the right lane. It's a right turn only lane. Then you would have had more of the traffic in the center lane, and they would have just passed through. That would have been a solution. So really what it comes down to is, I think the experts said you could probably get away with 1 gallon of paint and stencils, and you could have painted the markings on the roadway for right turn only, and you could have probably put in 2 or 3 signs for a few $100s, and this never would have happened. Like, all the county had to do was analyze it, come up with any type of solution. This was just what our expert proposed, but that this would have prevented this from happening.
Why does it take guys like us and a jury panel for what sounds like such a simple concept to be in effect in order to protect public safety? That is constantly the question I ask myself.
I mean, people don't self-police. I always think about it in terms of like an airline accident, right? Like, if there's a crash or slide off the run, any type of airline event, I mean, everybody, the NTSB, the FAA, they descend on that. They study it, they go through it. I mean, it's like this painful investigation, and they try to keep whatever happened from happening again, whether it needs to ground planes, whatever the remediation is, they just fix it. And so, percentage wise, the amount of plane crashes and events, it's like a statistical anomaly when anything happens to a plane, right? Then you look at the county, they're not going to self police. The traffic engineer actually had been away from the county for about 6 years. So they had no chief engineer during his hiatus. There was nobody there doing what he did. So when he came back a year before the crash, he's like playing catch up for 6 years worth of like essentially a mess. And they're just not going to fix things on their own. And it's not until people hold them accountable, right? Like, because what do we really do? We're not personal injury lawyers, we're deterrence lawyers, because what we do deters this conduct from happening again, because we bring it to everyone's attention, we make it hurt where it counts, and then hopefully change happens and they stop doing what they were doing.
That's exactly right. So, what did the jury find with respect to liability between the drivers and the county?
So that black car, they came back 70% responsible, which it makes sense, right? Like you saw she pulled out and maybe unsafe to leave her lane at that moment. The other vehicle that struck the black vehicle and also had pedal confusion, that was 3%, and the county was held in for 27%. So I think the verdict was like a fair assessment of what happened there.
And then you move on to damages. And in damages, we know everything is about sharing our client's human story. So, how did you go about doing that for this girl? Her name was Natalie. How did you build who she was prior to this accident before you got to what happened to her after?
So we met with the family. We spend a lot of time with the family. We need to understand them as a family, as a unit, where the child fits into the family. We need to understand their whole story. And by us understanding them as a family and their story, then we can come up with a formula with which we share their story with the jury in like a meaningful way. So they see her not just as, some poor kid who got hit by a car, and this is how I say it in my summation. I said, it's always someone else's child until it's not. It's always someone else's family that this happens to until it's not. And on that day when Mr. and Mrs. Cruz got the phone call, I want them to know that this could happen to anyone. There could be any random person in that intersection, that the danger at this intersection extended to everybody who was there. It wasn't just danger extending to Natalie Cruz and this other girl, Sydney, who was standing next to her, who bore the brunt of it. It was danger that was lurking that everybody was exposed to. And then I told the story of my client. And it was a very truthful, sad story because, her parents were immigrants from El Salvador. Neither one was educated, right? Mom had a eighth grade education and dad had a third grade education. And despite the fact that the parents didn't even speak English, here comes Natalie Cruz. And at 15 years old, she's acing her Regents exams as a ninth grader. She's got almost a 95 average. And we're not talking about like parents propping children up who need a little extra help here with like tutors and extra help and, services. This kid's trajectory was like straight up. She was an honor roll student. She was a captain of a lacrosse team. She was a soccer player. She was the goalie of the varsity soccer team as a sophomore. I mean, and when you explain to people, and we talk about lacrosse, we talk about soccer, you can say it in one sentence, right? But that doesn't explain her showing up at practice every day. The fact that she was grinding it out in practice, that she was a leader of people, she led her teammates. There were a lot of qualities that go into it. You can't just say, oh, she was the captain or she was a really good goalie. When you talk about what it takes for that person to get there, then they sort of understand who she was before this. And she had had her quinceañera party a little more than a month before this. And when you see her at the quinceañera, she's dancing, like you see her personality. And that's the reason we pulled all these stills from the quinceañera so you could see her. And then when you saw her come into court, it was a different person. So it was almost like through the pictures and even the records and the explanation of what she did before, the before and after was so stark.
The report cards, the pictures from the party, the talking about her athletics. What witness are you doing all this with? Is it one of the parents or someone else? Or is it her?
We had multiple psychologists testify, and there was a lot of, testing that was done of Natalie afterwards. So we would use the psychologist and they had reviewed the educational records because in order to come to a conclusion as to what the loss was, you needed to know where the baseline started, right? So in order for the psychologist to really give meaningful testimony, what they needed to do was they needed to say, well, we reviewed the educational records and she had like 100 average in Italian. She had a 96 average in global history. And they go through all of that. And then when they did the IQ testing after this happened and she tested at like a 73, which is borderline intellectual function, you see the loss, right? Like here you see this high earner, motivated, moving through life, and she wanted to be a NICU nurse. And now you have a child who essentially gets on the witness stand that she says, like, I don't really remember what happened a few days ago. Like, I know we met. You told me we met, but I don't remember. And I watched a video of myself at my quinceañera party, and I see myself, but I don't remember it. I don't remember anything from before when this happened. So there was just a lot to it. And so we put that information in front of the jury through a bunch of different witnesses. Even mom commented on the report card. There were a lot of ways that we put that out there because we wanted to reinforce it in the jury, not just show it to them once.
Take me through the order of your damages experts. I know you put a lot of damages experts on between neurosurgeon, neuropsychologists for PTSD, employability, TBI, economists. Was there a strategic reason to stack that many specialists instead of consolidating? Walk us through your decision there.
So typically what I like to do is I like to call a doctor from the ER. I'd like the doctor who sees the child or the victim the very first time. Because in a case like this, it was gruesome. But because of the scheduling, we weren't able to order the witnesses the way we wanted. So we backloaded with the mom and the dad and the child. They were sort of at the very end of the case. So we brought in, I think it was our second witness on day two in damages. And Judge Steinman, who oversaw this trial, he ran a very strict courtroom. Like there was no shenanigans, there was no horsing around. You lined up your witnesses, you gave everyone the schedule, and you called them, and you were on and off. And he made sure that we stayed on schedule. So the first witness we called, I think, was a treating psychologist who had done educational testing. Wasn't my druthers. I wanted the trauma surgeon. But on day two, we got the trauma surgeon, and we had like he's the chief neuro guy at the hospital where a child was treated. And he just had this recall of the entire case, all the surgeries, everything that was done. He came in with no records. He looked every part the brain surgeon. He knew notations in his record. He recalled meeting the child 2 years after the surgery. I mean, he was our most powerful witness on damages because he actually did two craniotomies. He talked about a midline shift in the child's brain. He talked about a phenomenon called blossoming, where despite the fact that they had opened the child's skull on both sides, had bilateral craniotomies open together, that the brain was actually so swollen it was expanding through the opening, and they call that blossoming. He saved her life, and it was very powerful testimony as to the extent of the damages.
As far as the defendant's expert, I believe they put on a neuropsychologist as well. Can you tell us a little bit about what they said and the jury's reaction to that expert?
They weren't going to call the witness. So I almost like bent over backwards because I didn't want there to be like a reversal by the appellate division because we didn't let them call the damages witnesses on such a heavy case. So we almost like the judge forced me to call all my witnesses. And I did in a group like Monday, Tuesday, Wednesday, I was done. And then we had to wait for like 2 weeks and ask the jury if they would come back. And it wasn't 2 weeks, it was probably like 10 days. Will you wait for them to bring their expert? And so I did that because I didn't want the case to be flipped on appeal. And I wanted them every opportunity to call the witness so that here we all wait 10 days and here rolls in their neuropsychologist. And to tell you that she was ill prepared to testify is like an understatement. Like the quality of witnesses that had been called before her and how powerful their testimony was as to how bad the injuries were. And then the defendants roll in this neuropsych who picks and chooses which tests to perform. She doesn't really review all the records. She reviews like a handful of MRI reports. She doesn't look at any educational records. She doesn't look at any records from the rehab. She doesn't look at any of the treating doctor's records. It was almost like this, what do you really want to call her for? But the way we looked at it was, if you're going to put her up there on the stand, we're going to take her apart. We're going to expose her. And by exposing her, we're going to expose the county for what you guys are trying to do here. Because you're already on the hook for liability. And the same jury rolled into damages. And now you're trying to pretend as if it's not really that bad. And this is your witness. And it was interesting, like the witness didn't identify her country of origin specifically. She said she came from the former Soviet Socialist Republic. And then when she talked about care and treatment for mental illness, I think at one point they said, like, geez, doc, what are you talking about here? You think that a neuropsych residential facility, what is it, like Shutter Island? Where do you think we're going to send the child? We're sending her for the care and treatment she needs, and you make it seem like she's going to the gulag. And that was sort of like the way the jury saw this. She said, like, yeah, if she goes into a facility, it's people who soil themselves, people who just talk gibberish and they walk around all day and they don't close the door when they go to the bathroom. This was their expert, you know, after 5 awesome damages witnesses had testified. They just brought this woman in. It was literally, she just got destroyed.
You mentioned to me, but I want you to talk a little bit about the other attorney, his style, his tactics, particularly when it came to the cross examination of your client. Can you tell us a little bit about what happened there?
I don't know if you ever heard that expression, styles make fights, right? Like when you have two big guys get in the ring and they're just banging each other, they're just brawling, right? Or you have, one guy maybe is a finesse guy and the other guy's like a brawler. So my approach to trials is I'm always trying to stay on the good side of the jury. I try to be very truthful. You never want to do anything like funny business in front of the jury because if you do, jurors see right through that. Like there's never a situation where you think like, oh, I got away with that. You never get away with anything in front of a jury. So the best thing to do always, just come armed with the truth. If it hurts you, all the bad stuff, get all the bad stuff out in your case in chief. You don't leave any scraps for the defendants. So we kept our house in order, right? We tried our case, any bad factoids, anything we thought would hurt us, we dealt with it on direct. We didn't leave any scraps for them. But the county attorney, he was abrasive and he was an older gentleman. So you would have expected like a grandfatherly approach to the child. And he would have been like, look, we're very sorry, but, we don't feel we're responsible. You would have expected that sort of dynamics, but he just came in there and he was just like abrasive with the child. He didn't say, good afternoon, my name is Mr. Smith or Jones. He would call himself in front of the jury by his last name, which just made him so impersonal that his attacks became, on all the witnesses. And he wasn't super prepared. Like he didn't have collateral stuff to cross the witnesses on. He just sort of was like winging his attacks, calling himself by his last name. He went after the child. She said some really sad things on direct, and he confronted her with those on cross and said, I find that really hard to believe. And she sort of snapped back at him, and they had this exchange. And at the end of the trial, I mean, there were so many instances where defense counsel either was just not giving the jury all the information. I had to complete things. I had to tie things up. I had to show how he'd taken things out of context for the benefit of making his defense a little stronger, and I knew the case, right? So every time he tried one of these things and I pointed it out to the jury, I think it had like a, palpable effect on the jury's, the credibility of defense counsel in the eyes of the jury. I think his credibility was shot. I think they saw him as being abrasive. And like even when he summed up on damages, he even remarked to the jury, like, I know you found me responsible in liability. I still don't think I am responsible. It was almost like he was engaging the jury in an adversarial way, the same way he had been confrontational with a TBI 22-year-old girl on the stand. Like it just doesn't play. But, everyone has their own style and maybe it's worked for him in the past. It just didn't work for him this time.
Never a good idea to disrespect the jury's prior verdict when you're still in front of the same ones. Anything else he said in closing with respect to the damages now, in terms of how much compensation was fair and reasonable? Did he make any outlandish comments during that portion?
He didn't, but one of the attorneys for one of the vehicles, like one of the defendant driver attorneys, she made some quip. She said something like, so it's not like Elon Musk money. It's not like she's a CEO of a company. So what's fair? Like, if maybe you could give her like $500,000 a year. Maybe that would be fair. And so, like, now I'm crunching numbers, I'm like doing the futures, and I'm like, so when I got up in summation, I said, like, geez, no one ever said she's Elon Musk. I don't even understand what that means. I said, but if they think throwing $12 million at this child is any measure of, helping her, or, they're showing their true responsibility, I said, that's just absolute lunacy. And let me tell you why. And then we went through the numbers, but he did say something interesting in his closing, though. He said, you all saw, Natalie testify. It's not like she's a basket case. And it was just like, how do you get up in front of a jury who just came back against you in liability? And you had the sweetest plaintiff up there, and you're going to get up and say she's not a basket case. He didn't suggest a number. One of the defense attorneys did not suggest a number, but then the third defense attorney, it seemed like she was just winging it. And she came up with a number that was just a pittance of what it would have taken to compensate Natalie for everything.
And so you did a couple of things in your closing that I need us to touch on. And one is I want you to explain to us what you did when you pulled up some of the transcripts from the trial itself and why you did that.
So counsel mischaracterized a lot of things. And, here in the age of AI, as I'm listening to his summation, I can literally pull things up out of all the transcripts because we go to the dailies. So he said, I was very respectful to Natalie, and you all saw that. And I was respectful to her while she was on the witness stand. And then I waited and I got up to give my summation. I said, with all due respect, I do disagree with what Mr. Defense Attorney said. And I don't want you to take my word for it, but this is exactly what the exchange was. And it was sort of like, question, I find it hard to believe you only have one friend. Answer, like, it's true. Question, I still think it's hard to believe. And it was like this exchange back and forth, which even when I say it, it doesn't have any effect, right? We're listening, I'm making a statement, we're recording an interview. But in court, when he almost wanted the jury to misremember what they had actually heard, and then you remind them of what actually was said, because it's emotions, are very helpful with memories, right? You may not always remember the words that were said, but you always remember the emotional effect things have on you, right? At points in your life, you say, I remember being there. I don't remember what's going on, but I remember the emotion. And that's what makes me remember or have a memory of an event. I always thought, like, when he was attacking her, the jury may not remember the exact exchange, but they'll know how bad it felt. So I went through a few things like that. And I read them, right. And it's a little boring, right? Who wants to give a summation and, start reading from a transcript? But it flowed in what we were doing. And it brought back to the juries, first and foremost in their memory of how disingenuous this defense attorney was.
Use any analogies in closing to help maybe anchor the large numbers that you're about to ask for.
So I used the fighter plane analogy. There's a fighter plane, and depending on how it's armed, when it leaves the ground, it could be anywhere from 350 to $420 million. This Raptor fighter plane, and when they build those planes, they spend millions of dollars coming up with an ejector seat that even if the plane malfunctions on the runway, they can literally launch the guy up out of the plane and his parachute will go off and he'll be safe. Or if he's making a maneuver at 6 Gs, they can eject the pilot safely from the plane. Why do they care so much that they spend millions of dollars on protecting the pilot? Because he's the brains of that plane. He's the guy who runs the whole plane. Everything starts and ends with the pilot. And in this case, where we have a TBI, unfortunately, there was no protection for Natalie's brain, but she's lost now the control of her. And then we went through, like, how bad everything was. But essentially, the analogy is when you lose the brains of the plane, it's like what happened to the client here. And I also use it's everyone else's child and everyone else's daughter and every other family until it's your own. And I feel when you say it and you have the right pause, and I'm doing my little shtick, it resonates with people because you can't violate the golden rule and say, how would you like it if it happened to you? But you can make people feel, right? Because trials are about emotion. Trials are not about numbers. Trials aren't about, facts and the law. Trials are about emotion, and emotions always determine whether you're going to get a favorable verdict or not. And if the verdict is going to be the right number, emotions drive verdicts.
Absolutely. Take me into the room when the verdict comes back. What are you feeling in that moment?
So the way the judge organized the verdict sheet, he had like all the past, like first four questions, and all the futures, like the second set of questions. So when they talked about past lost wages, I forgot that there was like that was the question. So I'm sitting there with the verdict sheet and they're like, well, what are the past lost wages? And it was like, and I just thought it was the number, like I was, in the moment. And it was say it was like 68,000 or 123,000, whatever the past lost wages were. And I'm thinking like, oh shit, I'm screwed. Like they didn't buy the wages and what's coming next is going to be even worse. But I had like mixed it up in my mind, what was, being read. And then like past pain and suffering came in at 10 million. And then when we rolled into the futures, they sort of gave me dollar for dollar for everything I asked. The emotions in the room, I mean, everyone who tries a case the right way, you bleed into your case. Like there was literally nothing that I did, for at least 6 weeks during the trial, like between jury selection and downtime, you have no life. And then you figure it takes 3 months to get ready for the trial. Even though I had litigated it and I knew the file, there's a difference between knowing the file and being prepared to try the case. So all that time, so the emotion, and I started hearing the numbers and I heard the number for residential care. Like I'm an emotional guy. I think the reason I can try cases is because I know what it's like to feel emotion. And if I can help the jury feel the emotion of the moment too, it was an emotional moment when that verdict came down. And you know what? Good for Natalie because she deserves every penny of the verdict.
The best trial lawyers not only have a high IQ, but a very high EQ, emotional quotient. You have to be able to not just share your client's story, but feel and understand the loss that they had suffered. You said to me, and this is a line that I say to myself quite a bit, but hearing it from someone like you, it means a lot. You're never at peace during trial. You said that to me about this one. Always thinking about the next day, always, on your toes and never really truly happy with anything until it's all over. Can you give any advice to trial lawyers, maybe on the younger side, or something that you do to kind of hold yourself together to be able to get through each day on such a long trial like this one?
It's like Mariano Rivera. Like every day is like a new day. If you blow a save the day before and you get called out of the bullpen the following day, you have to have a short memory. But I'm never complacent. Every witness relates to another witness. It's all part of the same fabric. So if I were telling a younger trial lawyer or a younger, like when I tried cases, I worked at a place on Court Street. I never really understood how everything just sort of like comes together like a symphony. It was always, for me, it was always like disjointed parts of something. And maybe the pieces of the puzzle didn't always fit perfectly together, but at least I put them on the table. But I just feel like you have to know your theory of your case. You have to know how everything makes sense. You have to take all of the bad stuff, even if it's bad stuff that you like, making a calculated risk. I don't know that they saw that in a record. Maybe I shouldn't bring it up, but listen, assume that all the bad stuff is going to come out and you never want to have like a, oh, gotcha moment. Don't be complacent. Get all the bad stuff on the table and the jury has to believe you even if it hurts. You have to be painfully honest with the jury because they sniff out a rat. And if you're a rat, that you'll see it in the verdict. Just be honest and be yourself. Like people get into trial and they get like stiff and sort of like, uncomfortable and awkward. You just have to be who you are. Be a people person in that room, but know your case.
Yeah, be prepared. What do you think this verdict means for other municipalities and how they think about their intersections?
And I got to tell you, well, it depends on what the appellate division does here. If they do the right thing, I think this is a verdict that really, I don't want to say sends a message because, geez, that's like the statement that always gets in trouble, but it lets these municipalities know that, there are other law firms out there too. When you do something like this, which is just neglect, at some point, something's going to happen. You can't just be like, cringing and covering your eyes and something bad happens and pretend it didn't happen. People like myself and other attorneys will hold them responsible and let them know when you don't do what you're supposed to do and there's a victim because of it, you're on the hook. And I hope they know right now they're on the hook for this.
Charles, this is exactly why I built this show. You went into a courtroom against a defendant that never once considered paying, who said straight to a jury's face, this is a money grab. And you came out with one of the most significant municipal liability verdicts in recent memory.
It was a good day for Natalie. I'll just put it that way. And let me tell you something, what they did to her, she deserves every penny. And it was 96.5 million.
Here's the truth that nobody outside this profession really understands. We don't do this for the verdict sheet. We do it because somewhere out there is a kid who used to be a captain of a varsity team, who used to have a future mapped out. And one afternoon, walking home from school, that future gets taken away by something that never should have been allowed to exist. Here in this case, a coroner that wasn't engineered right, a warning that was ignored, a county that had 108 chances to fix something and didn't take a single one of them. Insurance companies and government entities count on us to get tired. They count on families not having the resources to fight back, and they count on lawyers not having the stomach to go 15 rounds against an opponent with unlimited money and zero accountability. And what you did in that courtroom, pulling that cross-examination transcript back out in closing, refusing to let 108 accidents get explained away as not a lot, that's what it actually looks like to hold someone accountable when they never intended to be. And that's what being a trial lawyer is. That's what the show is for. I want to thank you for trusting us to come on to the show to talk about it. Thank you for the work that you do for your clients, for the people who have nobody else in their corner. And to everyone listening, this is Trial Bible. Take what you heard today, go use it for somebody who needs it. Charles Wisell, thank you for being a guest on this show today. That's a wrap for this episode of The Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.